Everyone, today we're going to discuss an important case which is concerning fair use. Now, a lot of debate has been going on about fair use. So, how much of something can be considered as fair use and how much of that can be considered as violation or infringement? So, as I have mentioned before, also the judges have very different opinions regarding fair use or fair dealing because the extent of copying or the extent of the AI generated output, how much of borrowed material it requires to generate an output which could be used by people is highly debatable. So there are a few case laws which we are going to deal with today, which has been dealt with by the US district courts, and we will be seeing a very clear pattern, or I may say a debatable pattern, where certain judges hold a very strong view regarding fair use, and those opinions are not aligned. They are in fact very contrasting and they are very different. And this is what makes these cases very interesting, and they basically stand out. And that is why we need to closely observe the differences or the subtle differences in the opinions which were held by the judges, and this would help shape our own opinion regarding the fair use. So I have close to 3 cases. I'm going to summarize them quickly for you, and then you can maybe get back with your comments on how you perceive these cases. So the first case is Barthes versus Anthropic. In this particular case, so we are going to be dealing with cases where we are going to be analyzing how Anthropic's AI basically processes data. How does it process the data? So does it work on pirated works? So does it store the pirated work, or is it okay for it to store pirated works and then use them to train its AI models and produce an output? So is the generative AI working on pirated works considered, or storing the pirated works and then training its models, large language models, on the pirated works, and then generating an output which is largely similar to the work which is held by a copyright holder such as Barthes, is okay according to the judge in that particular case? Or is it not considered transformative and considered to be an infringement? So this is something we are going to talk about. So in the case of Barthes versus Anthropic AI, the judge has a very different outlook. So if you see the excerpt which has been provided by Judge Alsup, he has very clearly mentioned that he has compared, in fact he has drawn an analogy, and he has clearly compared AI processing of information to human learning and processing of information. So under human learning, what happens is the process is very clear, and it is transformative. So it is not just merely using the pirated versions of the copyrighted work, and then just releasing that data and stealing the market which has been owned by the copyright holder, or which has been created for that particular copyright owner or copyright holder. It is not the case. What he believes is that although the pirated work has been stored and has been used to feed the data sets of the AI algorithm or the AI tool, and it has been used to train the AI machine, the AI machine has been using its transformative or its learning processes to slightly bring about variations and creativity to generate a data which is not anywhere causing any market dilution for Barthes, who is the original owner of that copyrighted work. So therefore, this particularly, the work which has been generated by that AI falls under fair use, under his opinion. So it is very less likely that there is a case of copyright infringement. Whereas in the case of Kadri versus Meta, there has been a very contrasting view which has been given by Justice Chabria. So what he believes is that storing of pirated works itself is going to be a problem. So if you say an AI is storing pirated works and is training its, and if the company is training, if Cadre, if Meta is training its AI on data sets which are basically copyrighted works which are owned by Cadre, then somewhere there is going to be a case of infringement, because you are violating the protection which has been offered to a copyright holder, and you are training your data set to produce almost exact copies of that work, so which is clearly causing brand confusion, and which is basically diluting the market, which has been allotted or categorized particularly for Cadre. So with regard to literature works or literary works, or with regard to any kind of work that classifies for copyright protection, or which is meriting copyright protection, if that kind of a work has been used as a training data set for large language models, and it is clearly violating the laws and the policies, and it is causing confusion among the consumers, then it is a clear case of violation. But these are two very contrasting views with regard to fair use, and he very clearly said that in the second case, even storing pirated data will not constitute a case of fair use. So this is two very different scenarios. So why do they have such divergent views regarding the same point, or regarding the same or very similar case? So he did not draw the analogy of human learning, which was drawn by the judge in the case of Barthes versus Anthropic. So therefore, why this sort of confusion and debate regarding fair use? So for that, we will have to explore another case, which is Thomson Reuters versus Ross. So now in this case, Westlaw basically had a number of judgments, and these court judgments also had head notes. So now what Ross Intelligence did was, to a large extent, it copied these head notes and all of these judgments, the language, the excerpts, and it sort of produced almost the same results, and it trained its data sets, or it trained its AI models on those data sets which are basically excerpts from the judgments, and borrowed a lot of its footnotes. But can this really qualify as fair use? Or does it look like it's competing with Thomson Reuters, who is actually the copyright author for those works, who holds the copyright and is the author of those works? So actually, can someone even be the author of a judgment? So that is then put to the originality test. So how original is the work actually which has been produced by the Westlaw Journal? Because even when you are taking excerpts from a judgment, or even when you are putting footnotes, there has to be some amount of creativity. It can't be a copy paste kind of a work. There has to be a certain degree of creativity, and in the selection process, in the way you sort of draft that particular excerpt, or you're changing words but without changing the meaning, or you're using your human intellect to process it another way while expressing that particular idea in another way. So then your work can merit copyright protection. So that itself is put to a test of originality in the first place. And then when an AI generative output comes, does that output then match borrowing, stealing, or copying? Or does Ross Intelligence does it have the capacity to generate something very different from what Westlaw has done? So, and with judgments, we have to be very careful. Even if the legal language is being changed or altered to a certain extent, even if we expect the AI to produce a transformativeness in the data that it is generating, the meaning cannot change. Or even if the color or character of the language changes, it could result in misinterpretation of the judgment or the ruling, which can be quite quite a disaster for the people who are trying to understand that particular judgment. So, but for research and teaching purposes, whatever amount of information is being used or consumed by the learners or whoever, the teachers or someone who's conducting a research, it falls under the exceptional case of fair use. So, what is fair use really then? So, because there are these varied kind of viewpoints or very divergent viewpoints which are there in the mind of the judges with regard to fair use, what is really fair use is something we must explore in depth and try and understand, because and that can only happen when we see these divergent views and try and explore further, because without understanding what each judge has to say, like for instance in the case of Thomson Reuters versus Ross Intelligence, the Justice Bibas, he was the judge in that particular case. He had his own argument where he said that the person who is aggrieved, the aggrieved party, should make sure that he has enough empirical evidence to prove his case, that he has enough content to show that the particular literary material that he has published and has a copyright over it is basically belonging to him, and there is evidence to prove that that material has been copied by someone else and has been reproduced the same way, in the same language, conveying the same information, because then we have a bigger problem of infringement. So these are the various intricacies or the various intricacies or various sort of details that we have to be very particular and careful about when we are discussing something related to fair use. So fair use is a very emerging development, and these cases were basically discussed towards the end of 2025. So we are just, it's a budding era, and we are getting into this particular era where generative AI can come up with so much and such different viewpoints, but where is the human learning analogy coming in? Where is the transformativeness coming in? Is there evidence to show that there is a difference between human learning and what the AI generates? So once we can clearly distinguish between the two, and once the aggrieved party is capable of providing historical evidence or empirical evidence to distinguish between the two, or show that their iterative prompts, user prompts, are very creative and involve human intellect, only then the human contribution can be acknowledged and the copyrightability of that material can be decided. So this I find is a very interesting aspect of AI and IPR which should be explored further. Let me know your thoughts on this, and then we can discuss further regarding the same. Thank you.